Short death, man.
It's 41.
Yes, 41. Series available, my lord. So kindly fix on, my lord.
Till 22nd.
In this, in 27.
22nd.
Man.
Deep love, Lord.
22nd, my lord.
Yes, yes, true.
Man.
Madly love.
Yes, Lordship, item 45. Can it be in 22nd, Lordship? It's came in order column, huh?
It is in order column there.
Yes, it will become actually motion, Lordship. I enclosed the I have some difficulty today also. Can it be in 22nd, Lordship?
No, as per you, it should not be in order column.
No, it should be motion, Lordship. If it is order, no issue, Lordship. Court can pass order accordingly. 22nd, Lordship.
Because it is fixed.
It will 45.
Otherwise, it is a fixed matter. In fact.
Yes, ma'am. Yes, madam. Yes, ma'am. I have some difficulty today, Lordship. No, can it be on 22nd?
Like, what it- You can go by. It- Why? But why? Because of it. Have you taken sketch for it?
Yes, yes, yes. Yes, yes, that is in hazard.
You want to fix it on 22nd?
Yes, ma'am.
May I please, sir? I pay for listing of anticipated bail application, my lord, day after tomorrow. There is some urgency, my lord. Poet is already granted bail during the vacation court lordship. I am the owner, my lord, of the wine shop, my lord. There is an illegal transaction. Therefore, I pay for listing for motion day after tomorrow lordship. I love best.
May it please, Your Lordship. As per instruction of our client, my lord, we'd like to withdraw item number 15, my lord.
15, no?
15.
15. 15 withdraw.
1.
Yeah.
It was the BA.
Yes, my lord.
You are MS B.
B.
Bora.
Bora.
Did you order to my MS B. Bora? That's part of the instruction. Okay, it will be disposed on with
Yes, ma'am. Obliged.
Madly Lordship. Lordship, I'd like to withdraw item number 29.
29.
It's 29.
Ismail.
It's scan copy was received. Right?
Yes, record, my lord. Scan
It's
copy.
it's a AB.
Yes, madam.
20.
Your good name?
B secure.
B. B. Okay, it will be disposed
Scan,
on
scan.
with.
Much appreciated.
May I please, Your Lordship? I have recommend item number 47, my lord, from the hearing column, my lord. We have some difficulties today, my lord. Can it be after a week, my lord? 47, my lord.
Otherwise, it's a case of 2012. After a week, that's
47. Any date, my lord, after a week.
sorry. That-
47 to
after
adjourn.
Obliged, my lord.
May I please, Your Lordship? Your Lordship, I pray for listing of a criminal petition for orders. Your Lordship, in this matter, I am for the respondent, private respondent number 2,
For criminal petition, you approach court number 18.
court number
Comment.
18.
Much obliged, Your Lordship.
May I please, I recommend for listing on Pomora for a bail application of it. For listing at bail application on Pomora Lordship.
Bail application.
Lordship. Is in custody.
Tomorrow may not be. I
Is
don't know.
in custody, Lordship, and
Day after tomorrow. Day after tomorrow. Day after tomorrow.
Day after
it is filed on yesterday also, that is why.
I don't know. The day after tomorrow.
Lordship, I beg to mention for listing of an bail application for the day after tomorrow. Have you
Lordship, I am for the item number 39. There is no case diary. Inquiry may be extended, Lordship.
Yes, Sharma. Case CD is
My lord,
available.
CD not here. My lord, kindly. So, my lord, kindly fix on my lord 12-8.
12-8.
12-8, my lord. Interim
For issue reminder. Inter be extended. You are on inter.
Yeah.
Inter be extended.
Thank you, ma'am. Thank you, Lordship.
Withdraw the case doctor. So day after tomorrow or tomorrow. Tomorrow.
Lordship, very present. Lordship, I wish to mention criminal petition number 745 of 23. Made listing on 19. Lordship.
No, today it is week.
Yes, 19.
Item number 19.
For listing,
Yes.
you are saying.
No. Item
Yes.
mention.
For listing,
Yes.
to approach the court number 18. You mentioned there.
Okay.
May I please, Your Lordship? Your Lordship, I beg to mention item number 5. And the learned counsel, Mr. M.A. Hussain, is out of station for some personal emergencies. Therefore, I pray for adjournment of the matter. Your Lordship may face the matter on Friday.
Friday not possible.
Ma'am, then Monday, ma'am.
This after
Your Lordship.
take it after one.
High level.
Lordship, I beg to mention item number 8, my lord.
8.
Kindly pass over the matter for the day. We have obtained the consent of the other side.
Yeah.
See, DRI.
My lord.
Yeah.
Yes, Lordship, we have obtained the consent already.
Anything. First of August,
If possible, by next week, your Lordship.
it was fixed. Methods have been fixed with like these 2 weeks. First of August, or August. 29.
29.
29.
Obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 24, Lordship. Lordship, in this matter, search sheet is filed, Lordship.
24.
24.
It's fine.
Our instruction line file, no? Yes, my lord, search it file, my lord.
Yes, what is the CS number?
Yes, my lord, 363, my lord. Stroke 2024, my lord, dated 24/6.
Not 363, my lord, 383.
383, yes. 383.
Dated 24/6.
Yes, my lord, dated 24/6. 24.
You are Mr.
PJ Doctor.
Okay.
Obliged, Lordship.
May I please your lordship, my lord? I beg to mention item 23, my lord.
23.
Yes, my lord. I am instructed to withdraw, my lord.
Yes, charge
This
sheet.
matter charge sheet is perhaps filed, my lord.
Yes, charge sheet file, my lord. We have already instruction now. Yes. Charge sheet number, my lord, 150 stroke 24, my lord, dated 30/6/24.
150. Yes, 150. 150.
Yes, my lord, 150.
Otherwise also it could be disposed of.
My lord?
Otherwise also it could be disposed of.
Yes.
You want to withdraw one?
Yes, my lord.
Get out. You are good name?
Take it out.
Take it out. Take it.
All right.
May I please, Your Lordship? Your Lordship, in this case, CD was called for earlier, Your Lordship, on 27/6/24.
Actually, my lord, it is listed in motion column, my lord. That's why, my lord. My lord, kindly fix on, my lord, 19, my lord, in this week, my lord. 18, on 18, my lord.
On Thursday, already, Your Lordship, 42 days. And on last occasion also, Your Lordship was about to grant bail to him.
Yes.
Already 42 days.
On 18.
On 18th Thursday, Your Lordship.
Okay, but if we are reaching remand.
Oblige, Your Lordship.
May I please, Your Lordship? My Lord, basically in this petition, my Lord, in 482, we have challenged an order of non-bailable warrant of arrest, my Lord. My Lord, the proceeding had been instituted under section, my Lord, 138 of the NI Act, my Lord. And the complaint had been already taken cognizance. And my Lord, initially I was appearing before the learned trial court. And my Lord, the learned trial court was kind enough to give me bail also, my Lord. My Lord may be pleased to find the order of bail is at page 35, my Lord. My Lord is at page 35, order dated 21/10/2019. Complainant is absent with the steps showing the cause. In the petition number filed by the... yes, my Lord. And what has happened, my Lord, thereafter I was either regularly appearing or in my absence steps were taken. My Lord, due to that COVID pandemic period and due to the expiry of my father, my Lord, there are certain lapse of communication with the, my Lord, counsel who was conducting the case, my Lord. And therefore, my Lord, there is an order, my Lord may be pleased to find is at page 42. By this, my Lord, order, the complainant is present, accused is absent, issue non-bailable warrant of arrest against the accused person as order dated 23/4/24. The complainant shall take steps immediately, my Lord. Fixed to 8/24 for appearance. Now, my Lord, this date of appearance is coming on August 2024. So, my Lord, my limited prayer, my Lord, in this petition is that, my Lord, I will appear before the learned trial court below on the scheduled date, which is fixed on 02/08/2024, my Lord. Until then, my Lord, this non-bailable warrant of arrest may be recalled, my Lord. And I will, as I was regularly appearing, as well as, my Lord, participating in the process, Lord, I have stated...
So against you, NBW were issued from since when?
My Lord, the non-bailable warrant was issued on, my Lord. This order dated is at page 42, my Lord.
No, that is subsequent order.
Subsequent order, sir. Yes, my Lord. No, my Lord, and the first order is at, my Lord. My Lord may be pleased to find is at 11/3, 28/2/2022 is at page 41, my Lord. It starts from, my Lord, page 40. The complainant is present, accused is absent with step height petition. My Lord has got it, my Lord, is at page 40. Accused is absent with step height petition bearing number so and so, stating therein that the accused could not come to the court due to illness and as such an adjournment is sought for. Learned counsel for the complainant has raised objection against the prayer made in the said petition, stating that the accused person has been willingly delaying the trial of the case. I have gone through the case record and found that the case has been pending for recording of statement of defense since so and so. Thereafter, on many days, the accused remain absent with step on so and so, and accused remain absent with step. Then on 27, he remain absent without step. Then on 6/1/2022, he remain absent with step. Today, against the accused is absent with step. The cause shown today is not found satisfactory. There is no mention in the petition as to what kind of illness the accused is suffering from. The petition is not accompanied by any medical document. None appear to give submission on the aforesaid petition. Considering the conduct of the accused person, as the case record reveals, and considering the ground shown today to be not satisfactory, the prayer for an adjournment is rejected. Issue non-bailable warrant of arrest against the accused person. The complainant shall take steps. My Lord, this is the first order by which the learned trial court below, my Lord, issued the non-bailable warrant of arrest, my Lord. Milord has gone through the various the order of this 28 to 20. It itself reflects, Milord, that there is no Milord. If I did not appear, Milord, I took steps, but only 1 or 2 date, Milord, due to some communication gap, Milord, I could not take steps, Milord. It is admitted, Milord, the case is pending from long, Milord, as my appearance is required, Milord, for the faster for the expeditious disposal of the trial, Milord. So, Milord, I will appear, Milord, only this non-bailable warrant of arrest, if it is remaining there, Milord, then I have an apprehension that I may be again put behind the bar, Milord. So it will not suffice any cause also.
The order of issuance of for the Planet 14 and on his appearance on his appearance it one that but around on 28 he did but that counts for complete was the and entry paper. However, the state but during the event, but was not that event. His report or subject of it about it and there was but complete from the order passed by the United Court, United with the 28 it's it for the state. However, on previous state that on no, on previous it absence considered and it was 40. You have submitted all the orders.
My lord, the up to, my lord, the last order.
No, you have not submitted all the order sheet.
Here in
because
this
the order sheet of the 27/12/2021 6 months is also missing.
Yes, yes, my lord. Those order we have not annexed, my lord, in this petition, but it reflects in the order dated, my lord, 28 to 2022, my lord, by which the non-bailable warrant of arrest had been issued,
Why?
my lord.
Half order sheet you have annexed? Why?
Lord, বাকী আমাক দিয়া নাই
and it was for it was fixed for different one of by order by and
My lord, next date is 0 to 0. My lord, I will appear, my lord.
Petition is disposed of, my lord.
Yes. Obliged, my lord, highly obliged.
May I please your lordship? Lordship, this is 482 petition with regard to the quashing of NBWA, my lord. My lord, in this case, my lord, the FIR was of 2009. The charge sheet was filed in the year 2014. From 2015, for a second, my lord, I take your lordship to page 34. 34. My lord could see 34. For relevance of this 34, my lord, 6/4/2015, my lord, he was granted bail by the learned trial court on his appearance on 1st on 6/4/2015, my lord, and I take to the last order at page 48, my lord, from 12/5/2020, page 48, the type of this, my lord, because 48, my lord, 12/5/2020, my lord, 12/5/2020, and then I take your lordship directly to page 70. For reflecting before the honorable court that he was, my lord, since 2015, my lord, since 2015, he was appearing before the honorable court, though in between he has left it, but he was appearing regularly. Then, my lord, may kindly be pleased to see at page 70, page 70, my lord, before page 71, for a second, page 69, my lord, page 69. My lord, page 69, I take your lordship to 11/3/2020. Accused is present, my lord, here in this case, and then the witnesses were absent, so the honorable court has issued summon. My lord, for ready reference of this honorable court, there were 10 charge-sheeted witnesses. 10 charge-sheeted witnesses were police witnesses or CRPF witnesses. Out of the 10 charge-sheeted witnesses, 7 were examined in between. 3 witnesses were called from initial period. They were absent. They were CRPF witnesses, 3 witnesses. So on 12/5/2020, my lord, to see the next date, PO, my lord, on rooster duty as lockdown situation continued due to coronavirus, fit case be posted for evidence on 6/7/2020. The next order of 12/5/2020. So then the, my lord, next order at page 70, the relevant is started from 23/12/2020. My lord, the period was all between, he resides at Arunachal Pradesh, my lord, at a remote village at Arunachal Pradesh at my lord, Parobasti at Lower Subansiri, my lord. He resides at that location of Parobasti, but still between the COVID pandemic also he was coming to the honorable court and he was appearing. Then is the engaged counsel of the petitioner stated before the petitioner that when the case will proceed or when we will be informing you. He is presently 70 years old. He has been all along the 16 years he has been coming before the court, my lord. On 23/12/2020, my lord, before the 4 days during the period of COVID pandemic also, the petitioner appeared. As the court was not functioning and again he has to leave back to Parobaste and communication because of the COVID, there was very less. So he was on reliance with the advocate. But the advocate did not inform him that the case proceeded again, my lord. From 23/12/2020, my lord, NBW was issued against the petitioner. But from 2015 till that period, during the phase of 10 witnesses, 7 witnesses were examined also, my lord. And all those 10 witnesses, leaving aside 1 witnesses, are either police or CRPF witnesses, my lord. So from 23/12/2020, because of this reason, my lord, petitioner was not aware of the continuations of his proceeding, and because of which he was absent. He is presently 70 years, my lord. NBW is issued, my lord. So, and in between, my lord, proclamation is also issued against the petitioner, my lord. I take your lordship to page 103. My lord. My lord. My lord, here in this 103, and my lord, there is no chances of the petitioner even to abscond, my lord, for reference of this honorable court, because the FIR was stated, my lord, that explosive items were found from him. FIR stated. All the witnesses are CRPF personnel itself witnesses. They have stated that fuse were and 1 cylinder was found from the possession of the petitioner. There is remote chances of even conviction of the petitioner for him to abscond also, my lord. For that reason, he was even regularly appearing. Even I have annexed all the witnesses' statement also, my lord. So, my lord, at 103, my lord, proclamation was issued against the petitioner, my lord. And so, my lord, and the son of the petitioner at page 109 has even filed a petition before the honorable court at Annexa 8, page 109. To recall the proclamation and the order of the NBW, my lord, the same was also rejected, my lord. At Annexa 8, page 109, the son of the petitioner has, being the father being 70 years of age, he has also filed a petition to call for the NBW and even to call for the proclamation, and that they were not in the knowledge of the state being passed by the honorable court, my lord. And at page 114, my lord, thus said order, the honorable court was pleased, my lord, to reject the application and direct the petitioner for appearance, my lord. Annexa 9, page 114. My lord, the next date is fixed on 18. I have not defaulted the trial since 2015, 16 years of a person's life. And that also, my lord, the FIR stated by the informant was that explosives were found. All the witnesses, there are no chance of even tampering, all the police and CRPF personnel. They have stated, even I have exhibited, my lord, if my lord would be pleased to peruse, if wanted, my lord, page 123 onwards. All were even substituted witness. They have stated that this was not recovered. The person has 16 years passed by. My lord, this person will appear, he's 70 years of age. 18 is the next date fixed. My lord, he may be granted with an opportunity. He will appear regularly on each and every date, my lord. And he was appearing, he didn't have, no, even during the COVID pandemic period, 4 days he have went, my lord. But Parobasti to Lower Subansiri to Lokhimpur during that phase was very difficult. And being a village man, my lord, he being at age also, my lord. So I humbly pray that on 18 is the next date fixed before the learned court below. He will appear on each and every day. So NBW and the proclamation may be recalled, my lord.
My lord, he is a person from Arunachal Pradesh, my lord. He wants to participate in the trial, my lord. My lord.
But there presiding officer was evacuated and the council for the ended council for the but the
My lord is referring to the first NBW, my lord. Page 70, my lord. (23/12/2020).
CRPF personnel.
My lord?
They are CRPF personnel.
CRPF personnel and police personnel both. My lord, 103. Page 103, 13 to 2020. 103, my lord.
However, in order that the accused was declared by the Trial Court after examining prior misconduct on pending trial is
Just Lokhimpur, not Lokhimpur. 18-7, my lord. My lord, mass obliged, my lord, highly obliged.
My lord, dispose of money. Lordship, accused is already enlarged on bail. As Your Honor, Lordship, I am page 9, Annexure A. So, accused was granted bail by the learned trial court, and later on, after filing of charge sheet by Annexure B as page 10, 18-3-23, he was again appeared before the learned trial court, and he was allowed to go on previous bail, Lordship. And thereafter, what happened, Lordship? So, accused was an alcoholic, so he was under treatment in a rehabilitation center from 1/2/24 to 25/3/24. It's Annexure D, page 12. So I am referring, Lordship, page 13, para E, Annexure E. So this is the imping order. Page 13, Annexure E. So wherever NBW was issued against the accused person, as he was not appeared on the date fixed, Lordship. So as he was in rehabilitation center, so he could not make contact of his advocate. So advocate didn't take steps. So NBW was issued against the accused person. I am referring it at para 5, page 4 of my application.
Already, my lord, some direction was issued, my lord, in the
Yes, additional affidavit,
first page, my
yes,
lord.
additional affidavits has already been filed regarding the clarification of that point, regarding difference in signatures, Lordship. And in additional affidavit, that's page 15, para 4, it has been clarified. Yes, additional affidavit, page 15.
That is in the record, my lord. Additional affidavit is also there, my lord. Yes, my lord. In the later part, my lord.
Later part. Page 15, para 4, it has been clarified, Lordship. Page 15, para 4. That I said that though I was discharged on 25/4/24, but I had some alcohol withdrawal symptoms at that time, and passing of time it was gradually cured. As I put my signature in the discharge form Annexure D on the day of discharge on 25/4/24, and at that point I was under alcohol withdrawal symptoms for which my hands were shaking continuously, and I even could not hold the pen properly. Under such circumstances, my signatures were different from the signature I put in the affidavit of the instant criminal petition. And para 5, that I said that signature has appeared in the Annexure D at page 12 as well as in affidavit at page 8 of instant criminal petition. Both are my signatures, and due to reason as stated in the above para 4 of this additional affidavit, a difference in respective signatures were seen. The clarification is made by the petitioner by this additional affidavit. So there is no negligence.
Actually, my lord, the signature, my lord, that should be verified by the by some expert, my lord. Merely, my lord, submitting, my lord, very big.
And thing is that, Lordship,
Shaking of hand, it is, my lord.
it's alcohol with the symptoms, Lordship. That is why Lordship has asked for a clarification.
Yes, your lordship order.
Pointed out by Mr. Gupta.
Yes, my lord.
Yes.
That he handed in the
Yes,
petition.
yes, my lord. I have gone through, my lord. As per your lordship order, my lord, death affidavit is filed, my lord.
And that has been complied with, Lordship.
That is complied.
That is complied with the reason that isn't mentioned, Lordship.
Yes.
And it is admitted he is an alcoholic person and he was in rehabilitation center at that period of time. And that is why he could not appear.
Our base procure the attendance of the go by the data sent for
Well, up to your lordship.
now we know what has happened.
Lordship.
You will know better what has happened in fact.
Yeah.
With the taking of hand
Yeah.
or
It is admittedly, Lordship, he is an alcoholic person and some nerve problem is there. This is truth, Lordship. Lordship? जी काकुच.
You allowed to remain on previous bill on which date? It's 11/2.
Yes, yes, already here. Previous ball order, yes, Honor. Annexure B, page 10. I am Imran Hussain.
Is there any rejection order there? Which order I guess you have found?
It's a imping order at page 13, Annexure E.
or the order sheet properly. Na? The order sheet was 9 after 11, 9, 11, 2020, date was 11, 12, 20. You have not annexed all these. Simply you have come to 9, 2024 so that the period can be made over. Showing his admission on 1, 2, and you annex the order sheet of 9. What about the other order sheet?
911 was annexed as an Annexer C, is 11, Lordship. This, he,
Where is the 11, 12? So not directly 11, 12.
11, 12 was
And
not
directly
there.
have come to 9, 2. So that period of description can be explained. If we suppose he admitted in rehab or so, in that case also he admitted on 1st of February.
1st of February.
What remain the other? Do you have the other orders? Do you have? Try to get the order sheet and submit.
That's it.
अपना नंबर
Yeah, please tell us. My lord, this matter pertains to Zimma of the battle nurse. And my lord, what happened, my lord, the battle nurse loaded with a vehicle met with an accident, for which, my lord, battle nurse were seized by the police. I approached before the CGM for granting Zimma, my lord. Accordingly, on hearing both the parties, London CGM granted Zimma, my lord. Although Zimma was granted, but police was not handed over the battle nurse to me. After 2 or 3 days, the police, my lord, the prosecution filed revision before the Learned Session. Learned Session stayed the CGM's order, my lord. And against this order, my lord, against this proceeding, I am before you, lord. My lord, kindly see the Zimma order, page 32.
My lord, LCR was also called for, my lord. It is received, my lord.
Received, my lord.
My lord, I have not gone through, my lord. Kindly after some time, my lord, I will. Maybe
Because the writing.
My lord, at 2
maybe.
Oh, my lord. Then, my lord, kindly fix on, my lord, tomorrow or day after tomorrow.
My lord, matter is very simple, my lord. The Zimma was granted.
Go to because LCR is called.
HF have received that.
Kindly fix on tomorrow, my lord. I will go. If possible, my lord.
Tomorrow, the list is already on. Tomorrow, minute before.
Then day after.
10 years, Thursday, Friday. Thank you.
19.
So what I'm saying was, wanted to still that too. But we are writing by 15.
Right.
So may not be considered by. So this is your 19th, then 18 may not be possible.
18 maybe.
18, I don't know, 18 may be possible. 19 is possible.
19. Much idea.
Yes, a cheated case, my lord.
Yes.
That the scan copy was called for, my lord. The case there.
Yes.
I have come.
Okay.
The case of FI was lost as way back in 12/6/2021, my lord. Occurrence of 9/6/21, my lord. Victim is a student of class 9, my lord. And at about 12 p.m., my lord, the sister of the informant, my lord, was staying alone in her residence. Then the petitioner, my lord, who was accused, entered her residence, forcibly raped her, my lord. She raised an hue and cry. And that is the case, my lord. Ultimately, they filed under Pocso Act, my lord. Charge sheet was filed. And Our evidence were also recorded. That your Lord will find. Our evidence has been already recorded before the
Who's victim's evidence?
election 2, my lord, page 20, my lord.
This is the evidence of the victim.
Victim, my lord, and evidence of PW2, my lord, that was also recorded as Annexure 5, page 22, my lord. So my only case before your lordship, however, so far as a medical report is concerned, there was no evidence of recent sexual intercourse, no evidence of pregnancy detected, page 27, my lord. No injuries was noted in the body of the person at the time of examination, either in the private parts or genital. Age of the victim also is 18 years or below 20 years. There is page 27. Page 27. There's a medical report.
Of your petition.
Yes.
Acha, yes.
So now, considering the stage of trial, my lord, already the question of influencing the witness there are, and moreover, because of section 29, burden lies on me to prove whether such occurrence took place. For that purpose, I am seeking bail, my lord, not for any other purpose, basically. Because since all the main witnesses were already examined, and only the remaining official witnesses are to be examined. So, then question of my defense will come now. So, for that purpose, I am greatly prejudiced because if I am jailed, if I am in custody, I cannot contact my lawyer, and I cannot bring witnesses also. So, for this purpose of preparing my defense, I am taking bail in this case. Otherwise, I will be highly prejudiced. In view of section 29 is concerned, because language is until contrary is proved. If foundation is laid, court will presume that offence is committed. Until contrary. So, his burden lies on me to disprove it. No such act has been taken place or no such incident has taken place. That is my submission.
In fact, when he is in custody.
She is custody, my lord, since 29/4/2023. That is more than already past 1 year in the month of April. Now, other than 3 months, my lord, already why not? There are 15 months in custody, nearly. So, considering that period of detention, also you are working.
My lord, the girl is 15 years old, is class 9 student, and the incident occurred on 9/6/21. Though during they are involving some village mail and all this, because of that, FIR, though it is not disclosed in the FIR, but subsequent statement come, FIR was on 12/6/21. So medical done after 4 days. Because of that, medical evidence not come, but charged on 31st of August 22. There are total 9 witnesses. And charges were came on 29/4/23. And on 12/5/23, PW1 as well as PW2. PW2 is the informant, both were examined on 12/5/23. And PW1, the victim, in 164 and as well as the deposition of PW1 clearly indicated, though medical was done after 4 or 5 days, because of that some medical is not clear. But fact is that yes, from 12/5/23, no further witness were examined. Summons were issued day by day. Total 9 witnesses. Otherwise, PW1, PW2 clearly implicated PW2, one is the victim. Only regarding delay in the process, that is I have to admit. Subsequently, earlier one present status report was also called for.
since 27th of March 24. This is not up to date, up to March 27, 3. Since then only 2 witnesses. Otherwise, I don't know. But, only 2. There is also May 23. No. 12/5/23. 12/5/23. 12/5/23. PW 1 and 2 examined. Since then, only regarding the delay. Otherwise, well, team examined. So he is for the informant.
I'm for the respondent. Okay. As my learned friend Kitty has already told about that, the incident occurred at 9 June 2021. And on 10th, as it was a Sunday, it was in the case diary, it is written, police could not arrange for the medical examination. And the medical examination was done only after 72 hours. So my part of there might be discrepancy with that. And they were doing rice mills and all village headmen had organized some meeting, and there the accused were being asked, and then he denied, and after that he was being examined. And in her 164 statement, my lord, the victim girl has said that her date of birth is 2006.
2006.
She was a minor there.
Now he is in custody.
And now
Yes,
he is in
now
custody.
he is in.
He is in custody since 29/4/23. For 2 years he is absconding. That's also one thing. Otherwise, since May 23, no further victim examined. I don't know, consider that aspect. I have tag marked the PW1, 165 I have tag marked.
Any other submission that he is a permanent resident of the city or
Resident of same village, Ulivu.
9th day.
Yes, ma'am. FIR was on
Around 12/6, but incident was
9/6.
9/6/21.
Incident is for the 19th.
9/6/21.
Incident is on 19th.
21.
21.
2021.
Incident.
9/6/21. FIR you will also find that is page
No, no, your
11, my lord.
Your petitioner is behind the bar since when?
He was behind the bar since I think 23, my lord. They have stated. Because at the time of charge sheet, my lord, he
Arrest
was
on 29/4/23.
23, man. Because he was declared abscond, man. At the time filing of the charge sheet.
At the time of framing of charge only,
He appeared, man.
he appeared.
29/3.
29/4/23.
29/4/23.
Under that, charges are also framed on same day, 29/4/23. Till framing of charge, he is absconded.
That you will also find in order sheet page 17, man.
That conduct also, my lord, may consider.
Page 17. Annex 3.
Plus, the delegated counsel court said that she was a victim at that time. I mean, minor at that time.
Yes.
And apart from them, what is your subject?
My lord,
Because as per him, was probably the victim and the one other witness that the informant has also been examined. Therefore, do you have any say that there is a chance of responding of this?
there are 9 witnesses, my lord. Only 2 are being examined. And most importantly, in her school certificate, Navadviti High School,
No, she is admittedly minor. We are not on this.
Yes, he is minor.
she was a minor. And my lord stated in her 164 statement that when she was alone at home, the accused came. Though the accused was known to her, he was a family friend of her father. He came and took the fact that no one was there in the house and forcibly raped her. Then she fell sick after that. She was having extreme abdominal cramps as well as she stated that she was bleeding. But it is surprisingly not detected in the medical exam because there might be discrepancy. After 72 hours, there was medical exam and she stated that she was bleeding.
But no injuries were also found.
After 4 or 5 days.
But
Yes, ma'am.
Adjourn the matter for time being. Kindly adjourn the matter time.
Here on the last
Time being.
Time being.
Here on
Time being will be, I don't know.
After
Yes.
15 minutes.
on the last occasion, updated status report was called for. Right order dated 26/24, Lordship.
Yes.
And office note dated 12/7/24 states, Lordship, that updated status report not received. Lordship. So let it come, Lordship, and the matter may be fixed after 2 weeks. That will be required, Lordship.
It's an NDPS matter.
Yes.
Targeted one or not?
Targeted one.
After 1 week, Lordship. 2 weeks is best. More late.
1 week, Lordship, may not receive, Lordship.
It was called on last occasion, Lordship.
1 week or
1 week.
you want any fixed date? You want any fixed date? Or after 1 week?
Fixed date, fixed date maybe.
Also matters of fixed. That's why I have some problem.
That's right.
6-8. 6-8 will be 2 weeks, na?
6-8.
6-8.
Very late, Lordship.
Huh?
6-8 is very late, Lordship.
1st of August can make it. 1st of August?
1st of August.
May it please, my lord. Hello, this is a 439 application, my lord. Here two petitioners are before your lordship, my lord, and quantity involved is commercial, my lord. My lord, two petitioners are before your lordship, my lord. My lord. And my lord, quantity involved is undoubtedly commercial, my lord. Now the thing is that they were arrested on, my lord, 9/12/2022. Now as on today, my lord, they are inside for 1 year, 7 months and 7 days. And my lord, till today, my lord, recently two witnesses have been examined. Lordship may kindly come to the FIR, my lord. That lordship will find at page 12, my lord. Page 12 is the FIR. Two witnesses have been examined, my lord. Now they say
status report will have to be updated, Lordship, because there are two witnesses examined that is not on record, Lordship.
last date, your lordship will have. I have the copies, my lord, because 3 copies supplied to nowadays, my lord. Can I hand it over? Now, as per the FIR, your honor, recoveries were made from 2 different tracks. So, PW number 1, he happens to be an independent witness. So, he in his deposition has stated that, my lord, recovery was made from 1 track only, and he is silent regarding the number and all these things. So apparently a dichotomy there arises, and he also has stated that, my lord, these two petitioners he did not see in the trap.
Yes, as per the PW1.
As per PW1. He happens to be the independent witness, my lord. Yes.
Not seen these two
Petitioners in the trap, And he says, my lord, that from 1 track recovery was made, whereas in the FIR itself it is written that recoveries were made from 2 tracks. My lord. And so far as PW2 is concerned, my lord, he is the informant whose examination chief is over, my lord, but cross could not take place because due to paucity of time. So as on today, after being in custody for 1 year, 7 months, 7 days, only 2 witnesses, my lord, prosecution has able to examine, my lord.
He is, as per the he is in custody.
My lord, he is in custody since, my lord, with all respect, 9/12/2022. And so far as this independent witness is concerned, he demolishes the prosecution case. Because case 15, Lordship will kindly have a look, specific, my lord, in the FIR itself. Last two paragraphs, if Lordship can have a look, my lord. Description of recovered suspected narcotic substances from vehicle number so and so. Lordship has found it from bottom, my lord. From vehicle number MN019912. These are the recoveries. Now, next, my lord, paragraph. Description of the recovered suspected psychotrops from the vehicle number so and so. So, two different vehicles and two different set of recoveries, my lord. Now, PW1 says, being the independent witness, he says that recovery was made from one truck only. And most pertinent is, my lord, he could not identify whether these persons were in the truck. My lord. Now, my lord, as many as, my lord, other 5 to 6 witnesses are remaining, my lord. In this regard, my lord, some judgments of our High Court and also Apex Court, my lord, wherein, my lord, considering the period of detention, my lord, they were allowed to go on bail. So I am placing those judgments, my lord. The period of detention is almost same, my lord, wherein bails have been granted, my lord. So I pray the same privilege, my lord, imposing any condition, my lord, that your lordship pleases, my lord. There is a coordinate bench of our High Court, my lord, wherein 1 year 6 months, and the other one is of Apex Court, my lord, that is 1 year 6 months.
Yeah, Lordship, the charge sheet was filed on 23/3/2023. 23/3/2023. Thereafter, Lordship, charges were framed on 23/24. 2024.
Case was filed on 22.
CS was filed on 2023.
No. Date is 20.
23/3/2023. 23rd of March 2023. 23. And charges were framed on 28th of March 2024. And Lordship, thereafter, Lordship, evidence was fixed. In between, Lordship, there are already altogether 6 PWs, Lordship. As my friend has stated that 2 witnesses have been examined. That is not on record, Lordship. I cannot comment on that. But Lordship, here what has happened, Lordship, one more co-accused was there who was Amir Khan, Muhammad Amir Khan, who was absconding, Lordship. I have gone to the record, the number of time bailable warrant as well as NPW was issued, Lordship. For that reason, the trial got delayed a bit, Lordship. But Lordship, after that, Lordship, on 3 occasions, Lordship, I have found that the presiding officer was on leave for some reason, Lordship. Thereafter, that is also one of the reasons why delay was happened, Lordship. But now, Lordship, when it was fixed on evidence in the month of April, Lordship, this year, thereafter 2 witnesses had already been examined, Lordship. And regarding, Lordship, the PW1, which has been stated that he does not support the case of the petitioner, we cannot go into the details of the testimony, Lordship, whether acquittal will be there or conviction will be there. But, Lordship, there are altogether there are 6 witnesses, Lordship. And out of those 6 witnesses, 2 more independent witnesses are there, Lordship. So, Lordship, their testimony are very essential, Lordship. And regarding, Lordship, length of detention, Lordship, trial is progressing fairly, Lordship. Next date was fixed on 4/7/24 for evidence. So, Lordship, there is no inordinate delay, Lordship, for my...
Four witnesses are already been examined.
Yes, Lordship. But on the record, Lordship, on the record, Lordship.
Record, as per record
4/7/24 was fixed, Lordship.
It was fixed on that day, 4/7/2024, as per
Yes. So Lordship, there is no delay, Lordship. That is my submission. And two more independent witnesses are there, Lordship. Their witnesses will be vital to the case, Lordship. So at this stage, Section 37 will be attracted. That they cannot let go of, Lordship. They will have to satisfy on that. That is my humble submission. So at this stage, this may be rejected, Lordship.
My humble submission would be, my lord, I have placed those judgments because in those judgments, my lord, 37 has been diluted considering the length of detention. That is why I have placed it. And my lord, practice this, my lord, I am behind since, my lord, 1 year, 7 months, 7 days. Whosoever is responsible, my lord, not concerned with me, my lord, because I am in detention. So I humbly pray, my lord, with all respect, following these two judgments, my lord, they may be allowed to go on bail, they will appear, my lord, on each and every day. Any harsh condition, my lord, I leave it to your lordship, my lord.
I'll pass.
Mine. I am obliged.
Lordship, matter may be passed over for the day.
Can copy.
Scan copy is already.
Out of 8 witnesses already 5 examined and still it is going on.
Your senior is not.
Yes, Lord.
So, have it submitted. Scan copy. August. This will be 6th of August. 6th of August.
Obliged.
Scan copy was called for lordship. It is petitioners are in jail since 14/10/2021 lordship. Almost 2 years 9 months as on today lordship. Charges have been framed on November 23 lordship. There are altogether 13 witness lordship, and only 2 witnesses have been examined till date lordship, and there is no hope of immediate culmination of trial lordship. Therefore, I pray for release on bail on the ground of prolonged incarceration lordship. I was judgment of coordinate bench of this court lordship. Warrant 2 years 3 months have been considered as prolonged incarceration lordship, and some of the judgment of the Honorable Supreme Court lordship.
You are relying on.
Lordship.
Yes.
Here again, Lordship, two witnesses have been examined. Both have implicated the petitioner's Lordship. Here, Lordship, apart from 22C, here again 489C is also there, Lordship, fake currency note. FSL report regarding the same, Lordship, regarding the fake currency is 15/12/2021, fake currency, Lordship, and regarding the contraband, Lordship, that is 23/11/21, positive for tramadol, Lordship. From the petitioner number 1, Lordship, Mofidul Islam, seizure has been made of one cartoon containing 42 packets of Simplex C capsule, Lordship. Total number 6048 capsule, Lordship, were recovered from the present petitioner, Lordship. Lordship, trial is progressing fairly, Lordship. Two witnesses have been examined out of 13, so Lordship, there is no delay, Lordship. That is my submission, Lordship.
There is also contradiction in the statement of the witnesses, Lordship. PW1 is the driver of the vehicle who is the eyewitness. He said that the contraband packets are found from the side dicky of the bus. But the informant is saying that the contraband was found inside the bus. So there is contradiction, Lordship. And this contraband are not recovered from the possession of the petitioner's, Lordship. So considering the long incarceration, Lordship, the petitioners may be allowed to go on bail, Lordship, on any condition. Public.
My dismissal of diary has been 13.
13, 14.
Oh,
13, 14 to that.
Already, yes. 13 is BA matter and 14 is AB stance. There is stance of the matter. Diary has been called for, my lord. Diary is there.
Charge sheet, Lordship, I will have to take instruction, Lordship.
No, otherwise as per the...
No, not that.
Your petitioner number is number 13. Your petitioner is in custody. When he is in custody?
Since 22/5/24.
But I am followed by the 1 month 25 days. He is a man of 65 years old, my lord. That also, my lord, on the face of the affair, there is section 12 does not apply. And definition of section 11, my lord, no ingredients is found on the affair, my lord. You also may see it, my lord. He is a man of 65 years old, my lord. They are living in the same compound. In that compound, she was taking birth the girl. Only he advised her not to take birth in the open space of the compound. That is the only sentence, my lord, used by the old man, my lord. Thereafter, the police made him native under section 12 of the Pocso Act, my lord. As for definition of 11, Pocso does not apply to it. Your lordship, my lord, may consider it.
Friday, Lordship.
Friday, yeah?
Friday.
Huh? Yes.
13 and 14 same.
Yes, pattern.
Sorry, before you start, several scan copy, I have not gone through thoroughly this scan copy. Have two or any short test date,
Have two then, my lord.
Because several scan copy you are doing. If or any sort of there for tomorrow.
He's in jail.
No, he's in jail.
Lordship, at 2 p.m. if possible, if he's not ready.
Put him out later.
Reference. Thursday, if
Okay, the Thursday. We're listing it on Thursday.
Thursday. Oblige.
Thursday is 18th.
no, this sorry,
May I please, Lordship? My lord, total page representation, my lord. The petitioner is behind the bar of, my lord, 35 days, my lord. The petitioner purchased the cow, my lord, for sacrifice of Eid, my lord. And the cow is already in the custody of the police, my lord. The cow purchased on, my lord, 12th of June, my lord, and on the very day he was arrested.
Your petitioner is the owner of the cattle.
My lord.
Your petitioner is the owner of the cattle. Owner.
Owner, no, purchased the cow, my lord. Petitioner. One from Abdur Rob. Owner is Abdur Rob, my lord. That cow purchased from one
You are
village.
not the, if you have purchased, you are the owner or the illegal purchaser.
Legal purchaser, madam.
You are the illegal purchaser.
Not legal purchaser, madam. For purchase for Eid purpose, madam. For Kurbani.
Purchasing a cow or a cattle for sacrifice for the Eid.
Eid, madam.
It is
From one
it is the illegal purchase.
But allegation brought against the petitioner is illegal, madam.
Anyway. So he is in custody since 12th.
12th, madam.
What about the city? Why is that not
yes, my lord, no instruction also given, my lord. Some Bilasti Parayas. 127.6 it was first listed, fixed today.
So what is your case? You have purchased the cattle? How many cattle?
As per FR 1.
One cattle, madam.
One cattle.
One. Only for sacrifice of Eid, my lord. Eid festival, my lord. Eid festival held on, my lord, 17th of June, my lord.
Yes.
And that cow was purchased on 12th of June.
What is the FIR?
FIR is page 8, my lord.
Particular page 12.
Particular is page 12, my lord. May I read, my lord? Respectfully inform you that on 11/6/2024 afternoon at about 1 afternoon, received a secret information received by the in-charge Lakhiganj police outpost, whereby he came to know from the side of Khudigaon towards Bashi area below, noted accused person chasing away a cow. On received such information, in-charge Lakhiganj outpost registered a report in the daily register book of the police outpost, file number 165 dated 11/6/2024, and proceeded towards place of Khudigaon area along with his in-charge Lakhiganj outpost.
On length of detention. And maybe mention, my lord, that CD, though signalers sent on the same day, 27 CQ have sent the signal, till then, my lord, CD not received and no information was received.
Not any
Nine.
but it was quite good. Oh.
SDGM Bilashipura. Bilashipura. Deep Tobi.
May it please your lordship.
Already submitted.
My lord, here I am not on the search sheet, my lord. I am on the violation of the law, 41A. Paragraph 7, specific prayer, my lord, I have made. Here is a public servant, my lord, having a grown-up daughter studying in certain medical college here. All along during his career, no whisper of allegation with regard to his character. Now, one fine day, from Morika office he came in, heavy rainfall was there. A Group D employee was there, and she was waiting with the umbrella. And being a person, he said, okay, fine, I will drop you. Accordingly, she entered into his car. Now, on the way, he purchased, my lord, a cake for his evening tea and all. And thereafter went away. And thereafter, the girls also got down from the vehicle. She purchased meat for her family. On the way, I dropped her. She invited me for having Lucy Bhaji. I had it Lucy Bhaji. She even, I received a call from another guest for dinner when she knows about it and she talked to that particular person. Next day, this affair comes in with regard to that I have touched her physically inside the car. And she got out of the car. Then for purchase meat, this is accepted in the admitted in the affair itself. But I have somehow managed her and come to inside my car. Now, these are the allegations wherein, on the basis of which I have been arrested on 14.6 is the affair, 15.6 is the, my lord, forwarding report. No judicial custody, nothing. Now, the offence is punishable maximum by 5 years, 3 to 5 years. So, my lord, the mandatory 7 years below the 41A is mandatory. But here it's not been followed. And as such, my lord, I am putting it before your lordship, my lord, today will be 31 days behind the bar. And according to the learned PP, my lord, with all respect, search sheet has been submitted. Why my detention is necessary? Why I'll go to the lower court below, wherein the mandatory provisions has been laid down and it has been floated. And there are instances wherein the Supreme Court has stated, if mandatory provision has not been floated, person has to be granted bail. In this humble background, I am praying for the bail of this particular person. No criminal antecedents, my lord. A girl making an allegation in persona, not in RAM also, my lord, in persona. Whereas I have a grown-up daughter to that aspect. Wife is, my lord, a person, a social person, and wife comes to it and certify with regard to a character of a person. But now it becomes very dicey for lawyers also, sir. We have fitted CCTV cameras in our chamber. Because this kind of allegation can come in, my lord. In one of the given cases, my lord, in Pocso case, in here, my lord has rejected this. And thereafter, this Mr. Fukan has moved that particular. My lord has rejected it after going to the record. Cross-examining of the informant and the victim. The court says, grant him bail because lot of contradictions has come in. So these are the misuse that has been there. I will defend myself to best of my ability, my lord. I am in suspension already. I pray my lord will kindly grant me bail. My lord, 41 non-compliance at page 25, my lord, will kindly see the forwarding report. No whisper of statement, my lord. The Y41A is not being complied with. At 25, page 25, my lord, will kindly see the forwarding report. And the law says with regard to ulterior judgment itself, that there has to be a checklist. And there has to be grounds. The Y41A has not been complied with. Yes, he has the right to arrest. Forward me to the court. But a reasons has to be reason on record that Y41A has not been complied with. And these honorable court, my lord, judgments here, in similar situations when 41A was not complied with, immediately granted bail, my lord. Amar High Court judgment duta diye. Eta PJ Soikia sir aru eta Robin Fukaner sir. Yes, didi duta diye. Aru eta itu punto dilo. Our judgment to itu Robin Fukaner sir. In Indian Supreme Court says, my lord, what is the consequence of non-compliance of 41A, my lord? That's in the last paragraph, my lord. It's been stated, my lord. The court will have to satisfy the absence on the compliance of 41 and 41A of the court. And any non-compliance would entitle the accused for grant of bail. And if your lordship sees the judicial order, my lord, the court satisfies itself. But the IO doesn't satisfy the requirement of 41A. And it's a perverse order, my lord. Not on merits, my lord.
Already, whatever notice, that is another thing, already submitted on 30th of June 24. Against the person under section 354, 354A, B, and D.
So I'll face the trial, my lord. Why my detention is necessary, my lord?
So he has to approve the court below that practice is going on.
No. Here I am praying for violation. And when there is a violation on the face of the record, the court will grant bail, my lord. Immediately, my lord. That is, my lord, entirely a judgment, my lord.
And regarding, my lord, as Pastor submitted, materials also not available before us, my lord. Neither the CD nor the otherwise, my lord.
No, I have made the materials available before this honorable court. The forwarding report.
Forwarding report is subsequent to that, my lord.
Yes, my lord. And let them take the instruction whether 41A has been complied with or not. Let us come back at 2.
No, they already submitted. So all materials are submitted before the court below. So either the scan copy has to call for
that
or
will cause delay, my lord.
It will cause delay. Then if you will approach the court below tomorrow or the afternoon, then immediately that can be.
No, my lord. Why I am saying so? A judicial order has been passed, my lord. You can see the judicial order. 41A non-compliance is important. Whereas the Supreme Court says checklist has to be there. Why not compliance? That is evident from here only. And these are the cases wherein by telephone instruction has been obtained. And thereafter granted bail immediately because this is a Supreme Court judgment, my lord, mandatory. So from the face of the record, 41A is not been complied with. Because forwarding report is the document itself, my lord. I would pray, my lord, no justification for keeping me behind the bar or sending me to the trial court again, my lord. And immediately after, as I have not moved this court, I have moved this court before the vacation, and after vacation it has been, at the PP's request, it has been fixed on 16, my lord. That is my 31 days detention, my lord. No criminal antecedents, my lord.
Pass the order or what it think that can be deferred
no material is before us, my lord. Regarding that 41 notice is the another thing, but regarding the material is not before us. Either he has to approve the court below, or my lord has to call for the scan copy.
I am sorry. The judicial order at page 27 reflects 41A has not been complied with. Judicial order says so. And he justifies non-compliance. I am sorry, this cannot be. At page 27, my lord will kindly see. Seen bail application praying for bail of accused persons. Page 28, all the submission has been noted down, my lord. Page 29, my lord, sections of law, paragraph 29, my lord, second paragraph. The learned counsel accused submitted under such circumstances in view of decision of so-and-so, the accused person, the learned submitted the arrest of the accused without a notice under 41A makes the arrest illegal. The learned has submitted decision of Guwahati High Court so-and-so. In the light of the submission made by the learned PP for the accused person, I meticulously gone through the evidence collected by the investigating unit, the forwarding report and other document in the case record. As regard the case law cited by the for the accused person, is stated a decision of the Honorable High Court in so-and-so. This has been discussed. I fully agree with the submission of learned counsel for the accused that in Ernest Kumar so-and-so, 41A. This notes down 41A, my lord. And he gives reasons why non-compliance is important. Whereas the mandatory provision that checklist has to be there and compliance. And admitted 41A notice is not there in the judgment itself. And the rejection is, my lord, under such circumstances, there is very likelihood that the accused person would try to influence the victim and other witnesses to decision by means of inducement so that further investigation in this case derail. Therefore, I am the considered opinion that non-issuance of 41A is not fatal in this case. Can it be, my lord? When the Supreme Court laws down the law under Article 42, it becomes mandatory for us. And the Supreme Court says in paragraph 100.3, the court will have to satisfy themselves on the compliance of section 41 and 41A. Here, 41 non-compliance has been, my lord, given reasons by the court that it is not necessary. This cannot be. And a citation to the non-compliance, my lord, one line more. Any non-compliance would entitle the accused for grant of bail. Yeah. এই কিতাবখনে দি দিয়া না স্যার কিতাবখনে দি দিয়া ইয়াতে কৈ আছে 41A কমপ্লেইন কৰা নাই yes 100.3 my lord that the operative portion directions my lord yeah এখন দিছে এখন দিছে না The court will have to satisfy themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail. Absolutely clear. And with regard to the checklist, my lord, that has been there in paragraph, page, my lord, 11.3. The police officer shall forward the checklist duly filled and furnish reasons and materials which necessitate the arrest while forwarding producing the accused before the magistrate for further detention. This is mandatory. So forwarding report doesn't say so. 41A non-compliance, no reasons been cited. And the learned magistrate on the submission of the learned PP says that it is not mandatory. Can it be that way? And for the sake of my lord, this, my lord, why my detention is necessary, my lord? I'll make myself available, face the trial, my lord.
Otherwise, already notice that regarding that 41 notice not fatal, that reason has been given by the Learned Court below. But now already suspected, so materials are not before us. So I thought that maybe even from Morigaon, my lord, can go maybe
Any person will be behind the bar. I am on that, my lord. No purpose will be served, my lord. Every day of detention is incarnation, my lord. I'll face the trial, my lord. I am not a thief. I am not a person with this, my lord. I am a respectable person, my lord, in the society. Everything has gone, my lord. That way I am praying with folded hands before this court. This court is almighty, my lord. Let justice prevail, my lord. I'll face the trial. Why my detention is necessary, my lord? All materials may not be there before the court. What is affair? That is the gospel truth. We take it. We'll face the trial. Prove it in the court of law, my lord.
Friday
from Morigaon. Come if today.
Thursday?
Friday. It can be registry will come. Morigaon scan copy.
May I pray one thing, my lord? So far 41A is concerned, the learned basis says that 41A is not been complied with. That is the end of the matter. Supreme Court gave 5 years, yes, it cannot be complied, but reasons has to be recorded in writing. There are no reasons. And Supreme Court directs in paragraph 100.3 says that non-compliance, grant him bail. Apparent on the face of the record, on 2 different occasions, my lord, this honorable court has appreciated it. And thereafter passed an order, immediately release him on bail. Every further detention would be illegal that way, that manner. I'll face the trial, my lord. That is my respectful submissions, my lord. I can pray only with folded hands.
Court below already given the reason, but because of the investigation was going on, and at that time of point of time, it is not.
My lord, in this judgment, I'm sorry, whatever he is submitting, if a IO fails to, my lord, comply with 41A, then departmental proceeding. And if the learned magistrates fail to give reasons, then it's different. That is paragraph, my lord. Notice of appearing in terms of 41A be served on the accused within 2 weeks from the date of instruction on the day of the case, which may be extended by the Superintendent of Police of the district for the reasons to be recorded in writing. Authorizing detention without recording reasons as enforced by judicial magistrate concerned shall be liable for departmental action by the appropriate High Court. Failure to comply with the direction aforesaid shall, apart from rendering the police officer concerned liable for departmental action, they shall also be liable for punishment for contempt of court. This is the law. And operative position, the last line is very important, my lord, in the judgment, until years. The court will have to satisfy themselves on the compliance. Here, non-compliance has been given reasons. There is no compliance, accepting. So, non-compliance has been given reasons. It cannot survive in that manner. Next line is, any non-compliance would entitle the accused on bail. I am on that. And why my further detention is necessary? My lord is supreme, my lord is above all the courts there, my lord, trial courts. I pray, my lord, pray with folded hands to my lord all discretionary power to grant me bail, my lord. That's what I make my submissions. Yes, deeply obliged, my lord, deeply obliged.
My pleasure, Lordship. It was called for.
Case they received, my lord. Initially, my lord, in this case was registered under section 365 PRPC. Later on, my lord, by order dated 12/7/24, section 6 of the Pocso Act added.
6 Pocso Act.
Yes.
6 Pocso Act.
Yes, 6 Pocso Act.
Lordship, FIR is page 9, Lordship. May I read the FIR? I respectfully beg to state that on 26/5/24 at about 11:30 p.m., my minor daughter, namely X, is about 17 years 3 months, was missing from my house.
After much more searching, I came to know that the above stated accused person abducted my daughter and kept her unknown place. That is the allegation, Lordship. Lordship, as on today, 48 days behind the parlor. And victim girl is already recovered, now under the custody of her parents. And Lordship, in this case, Lordship, accused person was forwarded under section 365. Subsequently, section 6 added, that is another aspect, Lordship. But in the forwarding report, in this case also not complied the section 41 is admissible. I am praying for bail at this stage, Lordship, on the ground of length of detention. And Lordship, victim girl is already recovered. It is now she is under the custody of her parent, Lordship. Moreover, 41 is which also. I will cooperate with the trial on any condition, my lord. You can. There is a love relationship actually between the accused and victim. And in persons of that their relationship, victim girl voluntarily eloped from their parents' house. Considering the length of detention.
Yes, otherwise, 164 statement she implicated, and from her, the incident occurred on 26/5/24, and her date of birth is 6/2/2007, so she is minor at the time of incident, and she implicated as per her in her 164 statement.
Because of their repeated.
Yes, yes. Yes. Yes, initially, my lord, she introduced with the my lord accused person in the. Yes. Okay, length of detention. And
48 days.
And the incident of kidnapping one another aspect, my lord, on 26/5/24. FIR laws on 29/5/24.
7 days delay. SDGM North Shalmara Ovaipuri it was initially, but after Pocso it will be special judge, I think.
Special judge or
North Shalmara Ovaipuri. Most of us.
May I please, Your Lordship? My Lord, in this case, my Lord, I am behind the bar since 43 days, my Lord.
In this case, my lord, treasury not received, my lord.
43 days, my Lord, and though the case is registered under 21B, my Lord, but my Lord, quantity is 6.53 grams, including plastic pouch, my
27 and 29 of the NDPS Act is also there.
Case number 12, my Lord.
I'll produce the case.
when you are in custody till 4/6.
4/6, 43 days, my Lord.
On 23rd, my Lord, I can produce
NDPS
that.
There is two sections. One is 21.
29 is also there, ma'am.
29, 7, 8. Not capital A, small a.
Yes.
And apart from that, 29. Is there any information why is that not?
No, my lord, only once initially matter was listed, only once, my lord, thereafter case diary was called for.
When it can be?
On, my lord, on 25/7, my lord. 25/7, sure.
It is not a commercial one, but
It is apparently small
25,
quantity.
No, or 20, 23 or 25.
Obliged.
May I please, Lordship? Item number 21 and 22, my Lord, are arising out of same FIR,
21
and 22, my Lord. CD was called for, my Lord.
Did you receive?
In this case, my Lord, before making the submission, I may be allowed to read the FIR, Your Lordship. FIR is at page number 14. May I read the FIR? I have the honor to report you that I met a girl at survey area about 3 to 4 days ago, she introduced herself as some Datta from Dibrugarh. She shared her mobile number to me, which is so-and-so. Thereafter, occasionally she used to call me to my mobile number on so-and-so and got familiar with me. On 12/6/2024, at about 4 p.m., she called me to her address and requested to have a cup of tea with her. Then I replied her that I am at office and can't go now. She again called me at about 6 p.m. and requested to go to her address. After completing my office work, I went to her address at Sandhya apartment at Bongful Nagar, Beltola Survey and met her. She escorted me to a room. When I and she were in the room and gossiping, all of a sudden a group of persons comprising gents and ladies entered into the room and started doing videography. Then they demanded rupees 3 lakhs from me. One of the gents identified himself as police officer and started writing my name, address, etc. in a notebook. One lady identified herself as police officer, but they were not agreed. Then they threatened me to harm my reputation and also damage the reputation of my family members, as I failed to pay the demanded amount of rupees 3 lakhs. The person who impersonated himself as a police officer started bargaining and fixed the amount to rupees 50,000. Accordingly, I left the place and took 1 hour time to arrange the money and decided to meet in front of Hotel Royal Di Casa. After about 1.5 hours, when I came back arranging rupees 50,000 to pay the so-called police officer, I came to know that the group of persons had been picked up by the police. In anticipation of any danger, I approached the Dispur police to seek help. After coming to Dispur police station, it came to my knowledge that they were not the real police and the case was registered. Based on this FIR, my lord, a case was registered under section 387 and 419, 120B. Now, my lord, clear reading of the FIR reveals that the FIR does not attract the section 387, my lord. Section 387, my lord, deals with putting in fear of death or of grievous hurt, my lord, and in order to commit extortion, and the punishment extends up to 7 years, my lord. My lord, clear reading of the FIR reveals that a videography was done by the accused persons in order to extort money, and thereafter the amount was settled at rupees from 5 lakhs to 50,000, and the informant agreed and the money was arranged, and thereafter the accused persons were already arrested by the police station prior to the lodging of FIR, and this FIR was lodged only in anticipation of danger. So at this stage, my lord, 33 days behind the bars, my lord. So the accused person at this stage may be allowed to go on bail, my lord. Since the sections under which the FIR is registered is not attracted at all, my. There is no danger, my lord, of death or of grievous hurt. It is just a case of extortion, and which is still an allegation, my lord. Because, my lord, the videography, my lord, simply sitting and gossiping at all is nothing to be extortion in this matter, my lord. If he is just sitting and gossiping, my lord, for time being the court presumes the FIR to be true. In that case also, my lord, if he is just sitting, my lord, and gossiping, there is no case of extortion, my lord. So kindly, my lord, my bail petition may be allowed.
My lord, otherwise from the allegations contained in the FIR and from the case diary, it reveals that, my lord, the present accused person, my lord, police has seized his mobile phone, the present accused person's mobile phone, and one of it, Abdul Malik Mullah, my lord, and also one of the diary of the Abdul Malik Mullah, and in that mobile phone, some of the objectionable, my lord, photographs were found by the police. My lord, it is specifically mentioned by the IO. And those accused persons, my lord, yes, it is true that, my lord, the present FIR is lodged, my lord, before the police arrested the present accused persons, before lodging of the present FIR by the present victim. Earlier, the police has also, my lord, one of the note of the IO that by earlier also, my lord, statement of the, my lord, entire incident occurred in a, my lord, apartment, my lord. And there are some of the witnesses of that apartment, security officer, that some of the illegal activities going on in that, my lord, flat, and thereafter, my lord, that is regarding that aspect, some evidence with statement of the witnesses is there. Police earlier know that some kind of activities is going on the basis of secret information. Police searched the, my lord, concerned flat, and thereafter, my lord, arrested these accused persons. And thereafter, during that point of time, as per from the contents of the FIR, as per the version of the complainant, my lord, initially that incident, my lord, occurred with the my lord present victim, my lord. What after my lord, all these, my lord, making all these photographs, my lord, while my lord, they pretend the my lord, present complainant that demanded money. Thereafter, my lord, while he has no money at that point of time in his pocket, and they asked him to, my lord, get that money from his family members. Then all those accused person asked him to go somewhere and, my lord, and thereafter collect that money. And during that point of time, from the contents of the, my lord, all the note of the IO and that police already arrested the present accused person. Thereafter, the present accused has also lost the affair by narrating his facts, my lord. And from the accused person says also, my lord, otherwise admitted that by wearing police, my lord, dresses, how they demanded money, and also took photographs of the, my lord, informant and the other, my lord, lady, my lord, who is also a part of the gang, my lord. Those witnesses are available in the case diary, and witnesses of the security of some of the, my lord.
Photographs of cosmetic or other any other?
My lord, those photographs were not available in the case diary, only stating that in the mobile phone of the Abdul Malik, the present petitioner, some, my lord, naked photograph of the, my lord, some of the lady, my lord, who are also a part of the gang, photograph is available.
But pilot, as per the
It is a
registration
fact
of the
that, my lord,
present
yes, the
FIR
present FIR
section,
is lost after arresting of the
after
present accused person. That is fact. That is regarding that note of the IO is also there. Because from earlier the, my lord, police, from other sources, police get the information, and thereafter during that search this incident happened and the present informant lost the FIR. This is the statement of the.
On the basis of the present FIR, they were not arrested.
No, my lord, before that lodging of the FIR, police already arrested them. Police stated that already earlier there is some secret
Is there
information.
any GT in that regard?
No, not.
that is a fact, Your Honor. Arrested
I will
prior
just
and then
check
after.
I will point out.
If we those parameter petitioner or the other experts were that suppose it connected with this case,
Yes.
then, or there may be some prior information.
I will point out, my lord. Okay. Regarding ZD entry, yes, my lord, one ZD entry is there, ZD reference. No, my lord, there is no such ZD entry in the case.
The another aspect, my lord, is that the case was registered under section 387-419-120B. In that case also, my lord, if after arrest also, my lord, then another aspect is that 387 is not attracted at all and rest sections are bailable, my lord. So in that case, I am behind the bars for last 33 days, my lord. So considering the length of detention and the submission that the section 387 is not attracted because 387 is deals with putting in fear of death or of grievous hurt in order to commit extortion. If for time being the court presumes that the statement made in the FIR are true, even then also, my lord, the 387 will not attract. So considering this submission, Your Honor, and length of detention, I may be allowed to go on bail.
some of the statement of the Malord, the security and some kind of illegal activities going on in that. That is regarding that only. That is the security
Some kind of illegal activities were that was the prior information.
regarding
So
that.
according to the Thursday House and
Yes.
for the arrest.
Yes.
I think that for that reason on that
Yes. Yes.
not
No. And IO Malord, in fact, in one of his notes specifically stated that Malord FIR before registering the FIR, he already on the basis of, but regarding that secret information, there is no such Malord info about the any GDNP. Nothing is there in the case.
and what about the other accused?
Here only one accused. Yes, other accused is also Malord,
Same
in the
FIR.
same footing, Malord.
Same foot.
Otherwise, their statement, in their statement, they admitted Malord. They are involved in this type of activity and
Accused
demanding
number
money.
5 and 6 as per the forwarding report. Page number 16.
The case we are dealing with is the dispute case.
Dispute PS.
587.
Yes, Malord. Dispute PS 587/20.
P. Mishra.
But the private Right. 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 Where is the case of dispute?
This
Up. Your order. Okay, got that.
much obliged.
Up. In order to describe but now we can not more but because it and everything.
May I please, Your Lordship? My Lord, the petitioner, my Lord, is behind the bar since 25, my Lord, 6. And there are two affairs, my Lord. The affair, my Lord, in which I am seeking bail, my Lord, pays 14 relevant, my Lord. And the second affair, my Lord, both the affairs lost by police officer, my Lord. And it is the first affair, my Lord, which has given birth to the whole incident, my Lord. That is, my Lord, relevant page 20. So this 20 affair, my Lord, has given birth to the whole episode, my Lord. Kindly see page 14, my Lord, where I am seeking bail, my Lord. Relevant page 14, 1-4. May I read, my Lord? With reference to the subject cited above, I am to state that on 23rd 6 2024 at around 1:30 p.m. around 300 to 400 people gathered in front of Bogribari PS in protest, demanding action against the accused person whose video has been circulating in social media, in which the accused person was seen saying
derogatory things against religion. In bracket, my lord, this incident and accused person pertains to Bogribari PS case number 55, 2024. Officer in charge of police station along with circle officer Bogribari executive magistrate tried to persuade the crowd to disperse. However, against the lawful instruction by the OC and the magistrate, the crowd blocked the National Highway 17 and started to become aggressive and tried to attack the police person and gauge property. To disperse the unruly crowd with the permission of the present executive magistrate, lathi charge was resorted to and the crowd was partially dispersed. However, some of the mob started to throw stone and used bamboo sticks, and they assembled with deadly weapons like bamboo, lathi, rod, stick, etc. with an intention to injure and kill police personnel and entered into the police station campus and damaged government property and vehicles. In the attack by the mob, some police personnel were injured and 3 of the gov vehicles of police department were damaged along with several other vehicles. In order to control and stop further injury and destruction of the police station, our police personnel had to resort to control fire 7 rounds in the air. After that, the mob could be dispersed. The videos recording during the incident are attached herewith for identification of the offenders and legal action against them. It is pertinent to mention so and so these people, 6 persons are named, my lord. Now kindly see the affair which was lodged by the police officer first, my lord. This is second affair where I am seeking bail, but first affair page 20, my lord. Page 20, my lord. With reference to the subject cited above, I am to state that on 23rd 6 2024 at around 12:07 p.m. it is come to know that from a reliable source, the wrong language, a person namely Anus, alias Imon Paul, son of so and so, village so and so, where he has circulated one video through Instagram threatening a particular community using slang languages and derogatory comments which may create disturbances, enmity between communities based on religion, and such act is prejudicial to maintenance of harmony. So, my lord, this affair, my lord, it was lost first by the police officer, my lord, against Imon Paul, my lord. Now, my lord, he has threatened a particular community, my lord, and he has disowned Almighty Allah, my lord. It was purely communal speech, hate speech, my lord, which created excitation, my lord, amongst the people. So 300, 400 people, my lord, they demonstrated before the police station, demanding action against that boy, my lord, who has made viral through Instagram. So, and after that, he was arrested, my lord. Now, what is my case, my lord? I was coming with my brother-in-law, who is a class 7 student. After his class, tuition class was over from Lashipara, I was proceeding to my home at Bogribari, my lord, near police station. I got stuck amidst the, my lord, crowd. Then side by side, I was coming with a scooty with my brother-in-law, and I stopped under a tree, my lord. This much. Now my presence may be ensured there in the video footage, my lord. So because of video footage, I may be, my lord, apprehended, and I may be. Otherwise, I am not named also, my lord. I am not named also, and since 22 days, my lord, I am, by this time, my lord, investigation might have been completed, my lord.
Here, Lordship, Lordship has already seen the FIR, Lordship. Here, this crowd, Lordship. This crowd was led by some main persons, Lordship. He has been identified as one of the main accused, Lordship. They entered into the police station, damaged 4 vehicles, 10 policemen were injured, Lordship. Although the injury are simple, Lordship, but swelling over back, swelling in the throat, bottles were thrown, bottles caused injury in the hand of the police personnel, Lordship. As a result, 10 persons were injured, police personnel. 4 vehicles were damaged, and it created a very terrifying situation in the police station, Lordship. And after that, Lordship, the police had to resort to 7 rounds of fire in the air, Lordship. It was getting very difficult to manage the crowd, Lordship, and it could have led to some untoward incident, Lordship. So that is the allegation. He is one of the main accused. That is the allegation. His involvement, Lordship, as stated by the petitioner, that he is not involved, it is totally false. He is totally involved, and the situation, Lordship, deteriorated to such an extent that police had to resort to fire in the air, Lordship. It is a very terrifying situation, Lordship. If Lordship can wants to peruse, Lordship, the medical reports are annexed, 10 police personnel, including the photographs of the vehicle, Lordship, which were damaged, Lordship. 4 vehicles were damaged. That is, Lordship, Bolero vehicle, 2 Bolero vehicles, 1 Winger and 1 motorcycle, Lordship, were damaged. That is the allegation.
6 persons are named, my lord. I am not within 6 persons, my lord.
You are not sick?
My lord, six persons are named in the affair, but I am not one of them. And my lord, page 10, my lord, I am a service holder, my lord. 6 persons named in the affair.
Where?
In the affair, my lord, page 14. Page 12, my lord.
5.
Page 12. These are the names, my lord. 1 to 6. I am none of them, my lord.
Also because at the time of closing of the FIR, the persons could not be identified. Subsequently, when video footage was analyzed, then only the other co-accused were identified, Lordship. And he appears to be one of the main accused.
Yes, my lord.
10 persons are there, Lordship. If Lordship kindly goes to the note, Lordship, first note.
I was a passerby, my lord. I was coming through the road and
not a
huge crowd was there, my lord, and I stopped under a tree, my lord. So that picture may be available in the video footage, my lord. I am not denying that video footage, my presence is not there, but the occasion is different, my lord. And my lord, 22 days, my lord, I will participate, my lord. I am a service holder, my lord, government service holder, my lord. I will not, my lord, flee from proceeding, my lord. Under any term and condition, my lord, my petition may kindly be considered, my lord, and I may be allowed, my lord. I have not come under, my lord, pre-arrest bail also. It's a regular bail. Local people created the problem. Again, local people helped the police person also. Otherwise, something, my lord, beyond explanation could have been taken place there. Local people, it is the local people who helped the police station, police officers also. Otherwise, his comments, my lord, derogatory comments, communal and hate speech was, my lord, to the greatest extent, my lord. Anyhow, my lord, I am not on merit. I am arrested and behind the bar since 22 days, my lord. I will participate, my lord. I am a service holder, my lord. And my home, my old mother suffering from great flood, my lord. My home is also, my lord, submerged under the water, my lord. I may kindly be, my lord, allowed to go on bail, my lord. AF Hanu Mullah.
uh, 7 rounds or but with a not and some other not and not like if but case that then paid of the submitted then the other person made of case the friend and the admin. That means 4 numbers of could it be apart from that they also affect this person for which and good person in that he alone was by who were accepted their people and if the and the and the uh, and there was a was that it was not controlled by opening 7 rounds of fire. Consequently, the victim of the statement availability is that the statement is I find that further custody can be from other some aspect as well as the other culprit in the above in the I find that not find the privilege of faith to bail petitions that's rejected.
Rejected, my lord.
Yes.
At this stage, my lord.
Yes, sir.
At this stage, my lord. Obliged.
May I please, Lordship? Lordship, in this case, Lordship, from these two petitioners, my lord, 49 gold biscuits were recovered, my lord. They are behind the bar for 42 days, my lord. It's under 135 of the Customs Acts, my lord. And my lord, since then, my lord, till date, my lord, the day I was arrested, my lord, because I have annexed the arrest memo also. On 4th, I have been, on 4/6, my lord, I was intercepted. On 5th, I was sent to judicial custody. Since then, I am there in judicial custody, both the petitioners, my lord. The recovery already...
Intercepted on 4/6.
Intercepted on 4/6. And, my lord, produced before the learned judicial magistrate on 5/6. Since then, these two petitioners are behind the bar. Now, my lord, the basic contention, my lord, of these two petitioners are that, my lord, they are only drivers, and that is also, my lord, authenticated by the seizure list, my lord. I'll just take your lordship to the seizure list at page 28, my lord. Page 28 is the seizure list, my lord. Now, lordship would turn to page 29. My lord, serial number 6, my lord. Serial number 6, my lord. Copy of the driving license of the first petitioner, my lord. And page 30, your lordship would find page 30, my lord. Serial number 14, my lord. License. Driving license. Now, my lord, the basic case was that, my lord, the owner. Now, my lord, again, I'll just place one more aspect, my lord. Page 29, my lord, would see the car also does not belongs to us, my lord. These two petitioners, my lord. It is of one serial number 7, my lord. Copy of the registration certificate of vehicle number bearing number so and so issued in the name of Sri K.C. Kapanyang Gay. So, my lord, we too were only asked to take the vehicle to Bimal Auto Agency at Jalukbadi, my lord, for, my lord, repairing, my lord. However, my lord, below the gearbox console, my lord, there was a chamber prepared by the owner, my lord, and there these biscuits were there. From the concise position of both the petitioner, my lord, nothing was recovered because I have also shown the inventory list also, my lord. From these petitioners only, my lord, the PAN card and the driving license. Nothing else, my lord. And some amount of rupees, my lord, 2,000 or 3,000 something was recovered from these two persons, my lord. That apart, my lord, the other ground which I am taking, my lord, is that the medical grounds, my lord. Because on lordship would kindly appreciate 5-6 order. This honorable court was on 12th of July, my lord. I placed the medical certificates, my lord. The petitioner number 2, daughter, my lord. She needs an urgent tonsillitis operation, my lord. So I placed those medical documents before the court, my lord. She was there in the hospital, my lord. She has been released, but she requests, because she is having DL grade 3 tonsillitis hypertension, my lord. So she needs an operation. And that apart, the petitioner number 1, wife also, my lord, out of panic attack, my lord, since they are behind the bars, my lord, she has also been admitted for a single day only. Thereafter, she was released, my lord. That medical documents also I am having, my lord. So, my lord, they are 42 days behind the bar, my lord. And not from the concise position, but from the gearbox console only, my lord, the gold biscuits were there. My specific, because, my lord, the learned court below, my lord, the learned additional session judge, my lord, at the time of rejecting the bail, my lord, would kindly see page 39. Page 39, my lord. Page 39. Sorry, my lord, page 40, my lord. Page 40, my lord. Second paragraph. Having gone through the case diary, I found force in the submission of the learned junior sentencing of diary in match. There are sufficient impediment medal against the accused person in respect of commission of the alleged offence. Further, the offence is cognizable and non-bailable, and investigation of the case is in progressing stage. So, my lord, that was on 3rd of July, my lord. The bail was rejected. Now, my lord, my other point, which I'll just place before your lordship, is that below 1 crore is bailable, my lord. That is already settled by the Supreme Court, and thereafter an amendment was there. Since the, my lord, the value is above 1 crore, my lord, so, my lord, it becomes a non-bailable. Rest, my lord, all other sections in the Customs Act are bailable, except, my lord, 104, my lord, and 135, my lord. These are the only two sections wherein, my lord, above, if the value of the seized item exceeds 1 crore, my lord, it becomes a non-bailable. So, my lord, we are ready and willing to cooperate, my lord. Whatever condition may be, if we are required to appear every 5 days before the investigation officer, we are ready and willing to. Mandatory days is 60, my lord. So, I am praying that, my lord, since any interrogation has been done after we are there, since 5-6 till today, they haven't done a single interrogation with these two petitioners, my lord. So, my humble submission, my lord, that bail may be granted at any conditions. I have also given the medical documents of it.
Lordship, my senior is on legs. Also, Lordship, the court has asked us to bring the case diary. We have bought it, but Lordship, my senior will assist you with this. He's on port 12 since morning.
Wait for
DRM.
He'll be up within 10.
He will not
because
be
by 60 10
Maybe matter may be fixed next day or day next day.
It is already up.
My lord, 40 days, 42 days, my lord. Yes, my lord would see. If my lord wants, I should be there for 7 more days. I'll remain, my lord. Because we are already behind the bar. For 4 to 7 days we are behind the bar, my lord. Even nothing will happen, my lord. My lord will pass appropriate. If my lord wants that fixed to some other day, my lord can do, my lord. We are already there in jail, my lord. If they want us 4, 5 days, 7 days more, we'll stay, my lord.
Not in a position to submit.
Correct, my lord, correct. I can understand her position, my lord. I can understand her position.
Is there? It is here. I also. You are out again.
In this case, Lordship, my senior will appear, Lordship. We have received case diary, Lordship. He is on legs in court number 12 since morning. 47. So, Lordship, matter may be fixed day after tomorrow.
So, doctor, matters are already been fixed. May not be possible. I think.
20. My lord, either on 23rd or 24th. We are otherwise in jail, my lord. We are praying that, my lord, 42 days. See, 5, 7 days more we will stay. Because 60 is mandatory, my lord. If they want us to be there, we'll be there. Part heard, my lord, and on 24th or 23rd, my lord, whichever.
23rd or 24th, is saying.
In the meantime, we will submit report.
For report, we are not give you any more. In the meantime, we find that it is that is okay. Otherwise, either 23rd or 24th.
Whichever. Because on 25th, I'm not in station, my lord. I'll be in Pagepur, my lord, for a case.
When is 23rd, find your report? I mean, objection if any.
We will try.
So try now. See, he is behind the bar. So today also your
42 days, my lord.
whatever, and your dinner is in other place in other countries. I cannot. But the question is that he is dead. That has to be considered. So do not try filing, or if you cannot file also submit perfect or it should be recorded.
Well, on the basis of the case diary only they have to submit, because separate report is not required, my lord. Whatever the progress is there in the investigation will be there in the case diary, my lord.
Probably also it can be put there. So, yes. Do we want to fix it on 12 p.m. available on 23rd?
23rd, 24th, I'm here.
Will be able. So let's be on 24th then.
Leave level, my lord. My lord, let it be part heard, my lord. After only their submissions, my lord, I have already made, my lord.
So take it part up. I said something happened. We will fix that.
Oh, like that.
Wait, please, Your Lordship. Lordship, this is a 438 bail application, Lordship. Here, Lordship, FIR on page 14, Lordship. Before Lordship peruse the FIR, Lordship, there is an order on 9-5, Lordship, call for the medical report, medical examination of this victim, Lordship. Whether that report is available or not, Lordship, that has to be taken.
So medical report is not here before Your Lordship, but based on the 164 statement, case can be decided, Lordship.
Okay.
Since, Lordship, the record was called by the judicial order that is on 9/5/2024, Lordship, that order is, Lordship, required because, Lordship, the initial case was registered, Lordship, on 8 of the Pocso Act, Lordship. Subsequently, 4 was added, Lordship. Now, Lordship, as per, Lordship, the Act, Lordship, 27, Lordship, the examination of the victim has to be done as per section 164A of the CRPC, Lordship. That has to be done within 24 hours of the record, Lordship, recording of the...
Whatever is submission of the IO, why he is not in a position to file
Lordship, on the last occasion, Lordship, CD was sent for updation, Lordship. But unfortunately, Lordship, it could not be sent, Lordship.
It could not be?
CD has not been updated, Lordship. So Lordship, either we will have to update the CD, but otherwise if Lordship kindly goes to the 164 statement also Lordship.
No, it's okay, but on 9/5/2024, one order was there
Lordship.
calling medical report.
Then Lordship will take it up after 10 days Lordship. In the meantime, we'll produce the medical report.
Or can it?
Or Lordship, I can.
If you want to, suppose in case return the case dead.
Otherwise, Lordship, I will take it on WhatsApp also Lordship. No problem.
Yes, that's what I'm.
Lordship.
CTP detail because 164 is already available in the record. And there may be, apart from that, the other cases are also there. There may be some, protest of the investigation that will try to get through WhatsApp also or by scan option or by through mail also. Then Mr. Chaudhary will take it on. Speak to
2nd of August, Lordship.
This is too long, Lordship. It's too long.
Right, keeper. It is 20, Saturday, 21, Sunday. At least it can be on 22nd next month. Next month.
Lordship, can it be on 26, Lordship? Can it be on 26? Friday, Lordship.
26 Friday?
Yes, Lordship.
I'm for responding private respondent.
Private respondent.
R Hawk.
R?
R Hawk.
R Hawk.
Sir.
There are 27. R Hawk, I don't know, but one dedicated count is there. You are Mr.? You have already engaged.
See, 26, Lordship.
Try to collect.
Highly obliged.
May it please, Lordship, on earlier 438 application, Lordship. On earlier occasion, Lordship, injury report was called for.
The injury report received, Madam. In the case diary.
Lordship, in FIR in page number 9, Lordship, type copy, Lordship. What happened, Lordship? The enforcement seeker, Lordship. He says a DI vehicle, Lordship, may I read, Lordship, FIR, Lordship? This is to report that at page number 9, Lordship. This is to report that at about 8:30 a.m. on 2024, the enforcement team was performing duties at Haukusi area. A DI vehicle was given signal to stop for the purpose of checking. The driver violated the signal and drove dangerously towards Haukusi riverside. The enforcement followed the inspector followed the vehicle in order to take photograph of the registration number. It was at this time a mob with wooden sticks obstructed the enforcement team. They physically assaulted the team, causing serious injury to Sri Sandan Burma enforcement seeker in the hip area and legs, making him immobile. Presently, he is being taken to JNRC Guwahati for treatment. The entire incident took place in the riverside South area near plywood factory, Lordship. Lordship, what the petitioner were not in vehicle, not the worker of the vehicle, Lordship. Petitioners are sawmill worker, Lordship. Once sawmill worker, they were present in the incident, Lordship, but they were not involved, Lordship. They were not involved, Lordship. There's just simple worker, Lordship. Then not connected, Lordship. Lordship, what happened, Lordship? During the sales, Lordship, the vehicle, the enforcement seeker vehicle hit a bicycle rider, Lordship, and bicycle rider got severe injury, Lordship. And that time, Lordship, the mob created, Lordship, and attacked the enforcement seeker, Lordship. The Lordship, in this, Lordship, he played away. They played away and received injury, Lordship. Nothing attack was happened, Lordship. Lordship, fell down, Lordship. Only non-valuable section, Lordship, T30, Lordship, BBS art, Lordship. Petitioner were, Lordship, only worker, Lordship, nothing, Lordship. Not in the vehicle, not driver, not seeker, nothing, Lordship. Your Lordship may kindly be because these photographs and my Lord injury report is also there. How they attacked the These are the accused person. My Lord, photograph number 4, serial number 4 is the victim, my Lord. He is Chandan Brahma, enforcement seeker. His injury report is grievous, my Lord. Injury report is also available, my Lord. Initially, my Lord, police signaled to stop the vehicle. While they did not stop the vehicle, my Lord, police followed them. And in the meantime, they make phone calls to all these persons, all gathered. And in a mob, how they attack all these, my Lord,
my lord, enforcement checkers, my lord. And the vehicle of the DTO was also, my lord, damaged by these accused persons. And this type of incident, my lord, continuously going on. They make phone calls and, my lord, hundreds, my lord, persons, my lord, gathered in a place and thereafter attack all these police personnel. And here in this case, my lord, is, my lord, enforcement checkers.
Lordship, petitioners are simple worker, Lordship. They have nothing interest into that, Lordship. Lordship,
They have no interest, then why they attack, my lord, all these?
it is a collision between sawmill owner, Lordship, and police personnel, Lordship. That is why our name has been given, Lordship.
Section 65P certificate is also available there in the case diary.
And we are not in vehicle, Lordship.
Injury report is
Yes, my lord, injury report I have taken out, the previous injury. My lord.
there, but not there.
Lordship.
But not there.
Lordship.
Oh.
Lordship. An incident was, Lordship, during says, Lordship, the vehicle, the enforcement checker's vehicle make an accident, Lordship, with a bicycle rider, Lordship. And he got received injury, Lordship. That is why he fled away the scene, Lordship, the enforcement checker, Lordship. And during play, Lordship, he got injury, Lordship.
How many petitions for that?
4, my lord. 4 person. 4 petitions.
Right. And,
4 person. 4 petitions. 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 4
enforcement.
Yes, my lord, enforcement.
By and for which is spot at the time of the for more I think when the loaded which was overloaded and what and it overloaded when the around 40-50 numbers were gathered there and the enforcement for which one under bomb your petition says reject.
Deeply
Regarding my lord, item number 21 and 22, my lord, at that point of time, my lord, I submitted that police before lodging the my lord, FIR. Police already arrested. Regarding your lordship has asked me regarding any ZD entry was there or not, my lord. But my lord, later on at that point of time, I could not point out your lordship, but GD entry is there, my lord.
In item number 20.
Item number 21 and 22, that's honey trapping case, my lord.
But one, 21 and 22, GD entry was there present connected with this case.
Yes, in connect, because police already arrested the accused person before lodging the FIR. Before, earlier, on the basis of source information, police searched that residence, and my lord, thereafter arrested all these accused persons, my lord. And at that point of time, your lordship has asked me whether there was any GD entry is there or not, my lord. But at that point of time,
Not on that. I was asking you that obviously after filing of the FIR or whatever, when the police went to the place and all, one GD entry will be there.
Yes.
On the basis of the FIR also one GD entry will be
Yes.
But I'm asking they visited place of occurrence with a prior information that some illegal activities
Yes,
are
yes,
going there. So in that case,
yes.
they
Yes.
were there by giving any GD entry.
Yes, my GD entry is there regarding that. At that point of time, I could not point out.
But the GD entry regarding the information they
Yes, yes. Well, I am handing over the case diary for your lordship. That mark the GD 21 and 20.
21, 22
21,
was supported by Rama, right? Okay, I'll make the correction. That is, okay. And,
Maybe lordship has asked the order for
yes.
11, 12, but lordship, I'm able to produce it on tomorrow only, lordship. If lordship. Tomorrow, lordship. But what happened? I sent my junior there, but he could not place it there in chamber.
But what I'm asking you that orders are relevant in fact.
Order is relevant
because you have submitted.
Yes. Lordship.
Yes, on 43. Not 43. Prior to 9/2.
Prior to 9/2, I'm annexing the 9/11 order dated 9/11/23.
Thereafter it was the fixed date was on 11/12.
Yes.
Most probably after 11/12 one more date may be there because 1 month
Yes.
time is there.
Yes.
So 11/12 order of 11/12 is also not available, and that apart the other date is also not available apart from 9.
Yes, lordship. But in online e-courts apps in online service, it was reflected as that bailable warrant was there. ₹1,000 bailable warrant issued against the Imran Hussain.
In which date?
On that date, 11/12. And lordship, kindly bear the imping order. I kindly refer.
No, I won't hear the matter now. If you want to fix it tomorrow,
Tomorrow, lordship.
Anything is supplementary. Tomorrow he just will. And the half portion I have given it to whom? Lipa. Up in the note packet for Lipa of the other. That will be it. So otherwise, will be set tomorrow. Tomorrow is 7. We just fund will see it tomorrow.
Lordship, I'll produce.
Right, please, your lordship. 438 application lordship. FIR lordship will find page 13. Here in this case, down below your lordship will find that on receipt of information they proceeded to a place, and then last paragraph I am reading lordship. I along with the police party proceeded from PS to Musalmanpara Panchayat Road, and on arriving we found one male person standing in the roadside and identified himself as Minhaj Ali Sheikh. So I am not Minhaj Ali lordship. and caught him red-handed in presence of below noted independent witnesses. Accordingly, from him, Lordship, 4.10 gram of heroin was recovered. And now, Lordship, may kindly turn to the first paragraph of page 13. Here, their initial information was that Shahjamal Sheikh, that is the present petitioner. How this person was apprehended, nothing is there. Because they were coming to apprehend the present petitioner. And in between, on the way, they apprehended this person and recovered 4.10 gram of heroin. Now, this man named that he has purchased the article from me, and accordingly, the police visited my rented house. From the rented house, Lordship, there are other tenants also. So, police allegedly said that from my rented house, they recovered the article. So, whether there is specific fact that how this person was identified, who named me, Lordship, and from where it was recovered, whether the specific thing is there, I have nothing to say. If it is not there, then probably I am entitled for bail, as 37 is also not there. This is below commercial quantity, Lordship, intermediate quantity. 37 gram allegedly recovered from the house from where I was residing as a tenant. Some other house was also there, so that part may be verified from the case diary. Because in the FIR, I do not find any sentence where it is said that that lock was broken or the doors were open, they entered. Those things are not there in the FIR. So how they identified that aspect may be verified. Because my case is that those were not recovered from my house. It was maybe from my compound. There are other tenants also there. In page 17, your Lordship will find that first seizure is at Musalman Para, and then second seizure, page 19, that is at different place. Within half an hour, they seized all these things.
Yes, my lord. From initially, police arrested Minhaj Ali. From him, my lord, some of the my lord contrabands were recovered, and thereafter, on the basis of his statement, while police searched the residence of the present accused petitioner, my lord, then police recovered my lord 9 numbers of small plastic container, and my lord containing 37.63 gram of brown sugar, and my lord cash amount of rupees 83,000. And my lord, here this is the statement of the witnesses, and my lord. And statement of Minhaj Ali that those brown sugars were recovered from the possession of the from the residence of the rented house of the present petitioner.
How Minhaj Ali was identified, that part may be seen, because initially Minhaj Ali was apprehended. They had the information that present petitioner was having some contraband. So they proceeded to arrest me. In between they arrested Minhaj. So how Minhaj came to the picture, Lordship? That aspect may be verified. Because my whole case is that he planted me, Lordship.
Those things will
how
come
he
during trial.
He came to the picture.
If at all they have the information about me, they could have directly come to my house to apprehend me. In between, when they were coming from PS, they apprehended one Minhaj. How he was apprehended? Because they certainly they would have met hundreds of persons in between the road. Okay. Why one person picked up and from his position it was recovered? And he said contraband is in my house.
Now, my lord, admittedly, my lord, 37.63 gram of brown sugar were recovered from the present petitioner. And regarding how Minhaj Ali was arrested and thereafter, on the basis of statement of the Minhaj Ali, that my lord, he, my lord, collected all these, my lord, brown sugars from the present petitioner. Those things will come during trial. But my lord, now this is anticipatory bail application, and from it is a fact that my lord, from the my lord rented house of Shahjamal SK, and from the witnesses also stated, my lord, this 37.63 grams of brown sugars were recovered, and case amount of rupees 83,000.
Whether any specific place was mentioned in the case diary or not, that may be kindly verified. Because my whole case is that it was from the compound where he was residing as king.
It is specifically mentioned that search the house of Shahjamal SK, son of Abdul Bari.
So inside the house there must be some specific place that it was kept in the concealed in the table, under the bed, or cloth rack. Somewhere it has to be there. Simply by saying that in the house there are many houses, that is what I was placing before your lordship.
No, but from your rented premises only those things were recovered. Obviously, you are saying that in your that they compulse there are other
other things,
but it was recovered from your rented house.
Specifically mentioned.
Specifically, that has been mentioned. But where from?
And how they entered the house, there has to be something in the case diary, lordship. They have to mention, because the house was locked, how they entered. Who identified that it is my house? That those things are whether it is there or not.
That when they arrived in the house of
Shahjamal SK.
If I am not there,
and with the
yes,
considerably or with the after a discussion with the local other people.
It is also mentioned in the FIR, but at that time.
Then they entered.
And those are independent witnesses.
If it is not there, that is what I was placing before your lordship, that initially Minhaj was arrested. How he was arrested. Therefore, I was placing before your lordship. Because in that circumstance, lordship, the involvement of third person cannot be ruled out, lordship.
Those things will come during trial, man.
Because I have to appear before the IO, I will have to give my statements. If I am taken into custody, they will accept whatever they want, lordship. They will not listen to me, lordship.
They apprehended Minhaj as per the report of the IO because he was in a suspicious.
Yes, suspiciously moving. Yes,
when after seeing police in his own statement, or he saying that
yes. Yes.
And then on suspicion, initially he got arrested, and then he disclosed his identity as Minhaj.
And my lord, this type of this business is going on in that area, my lord, in my lord, surrounding of his area, my lord, because he is supplying, my lord, as per the allegation, supplying all these brown sugars to maybe right now police has arrested my lord the present Minhazul. Maybe my lord.
But still, as we have submitted, let's see if there is any other note.
And it is intermediate quantity and no other criminal antecedent is there. That may be taken into account.
Antecedent in a sense,
because the
only
37 bar is
as
not
per
there.
the FIR or as per the note of PIO, police actually visited to your place to apprehend you.
Lord.
But in
On the basis of the
on
information.
the basis of this submitted information. So earlier, any
No, that I have stated in my petition also, and subject to what my learned friend says, probably in case that they will also not find, because my specific instruction is that no other criminal antecedent. And because 37 is not there, therefore I am submitting that antecedent above antecedent.
about to be 3:15. Then I'll just go by the ones that we have submitted, that whether there is any code or how the identity was.
And one more thing. Okay. And one more thing. Any they have found any other material to connect me with Minhaj or not? That part, because my learned friend has said that he has procured the articles from me. So they could have found any material or not. That.
In other matters, whether PD was there.
Yes, well, in some of the cases.
In how many numbers of cases?
31 my lord is there. Next item 31.
CD was there.
CD is there, my lord. Interim, my lord, that may kindly be continued.
Interim was there.
My lord.
Kindly item number 35 may be fixed on Friday. 35 CD is there.
Friday, I mean, lots of matters this week actually. Prior to vacation, we fixed 16, 17, 18, 19, lots of matters this week. So that's why fixed matters, you can see, I think, fixed matters, a lot of fixed matters are there. Those matters were fixed prior to vacation, in fact. So Thursday, Friday, some matters we have fixed, but I don't know. You are on interim, otherwise?
31, my lord.
You are on interim.
Item 30.
Interim be extended.
And
you want to retain the case diary?
Yes, ma'am.
Till when it can
my lord, because in these cases, case diary is available any sort that as per the convenience of your lordship. Item number.
So I need, with which item you have received?
Item number 31,
yes.
32, 34, 35,
35,
40, 41.
41 is already.
Yes, 43 and 44.
Because in 32, there is an interim order, that may be extended.
They have already received it. And just consider whether those methods interim was there. If interim is there, then we can adjust it to next week or in the month of August. Mr. Potakur, if it is, there are some cases where the petitioners are on interim, in that case, we may extend it up to month of August.
Yes.
And those where interim was not there, in that case, we'll adjust it next week.
Yes.
We'll try to. Otherwise,
Briefly, Lordship, item 33, Lordship. In this case, Lordship, today is the third day that matter has not been reached. And earlier, today also CD has not been received. Today is the third day, Lordship, CD has not been received, Lordship. So I am not on interim, I am a service elder, Lordships. So, my Lord.
In that case, what I am saying, that where the interim is not there,
yes, Lordship.
We try to adjust this. This week may not be possible.
I am a service elder, Lordships.
I may be next week. either 22nd, 23rd, 24th will come. That's why